Hi guys, I'm Gauri and I'm a legal intern at LEXIS and Company. I'm from Symbiosis Law School, Pune, and today's topic for the video is Special Marriage Act. Now, what are the conditions relating to the solemnization of a special marriage? This is covered under Section 4 of the Act. It says that neither party has a spouse living. It means that the person is either divorced or they do not have a spouse living. They are not married to some other person. And neither of the party is of unsound mind. They are capable of giving valid consent and they are not suffering from any mental disorder. Also, the specific age for a male is 21 years of age and female is 18 years of age. And they should not be within the prohibited part degrees of relationship. For example, under Hindu Marriage Act, we have the Sapinda relationship uh, that comes within prohibited degrees of relationship. Now, notice of intended marriage. It has to be in a specified format of scheduled second. Also, it should be given to the marriage officer of the district. And at least one of the parties to the marriage has resided for a period of not less than 30 days immediately preceding the date of notice. All right. Also, the marriage section 6 of the act, it talks about marriage notice book and publication. It has the record of all the notices and the true copy of notice and book of notice has to be there. Inspection should be there and it should be without any charges to the person, to any person. And also publication of all the notices to some conspicuous place of his office, of the office of the office manager or the marriage officer. And also, if either parties are not residing within the local limits of the district, also then it has to be published. Now, objection of the marriage. This is covered under Section 7 of the Act. Objections can be raised to marriage within 30 days from the date of publication. After 30 days from the date of publication of such notice, marriage can be solemnized, and nature of objection shall be recorded by marriage officer. Section 8 talks about procedure on receipt of objection. And when somebody objects to a marriage, to a particular marriage, there'll be inquiry into that objection. Also, the period for 30 days after objection is made has to be given for inquiry. That is, for example, if someone makes an objection on the 27th day, so it's 27 days plus 30 days. That means 57 days for first objections, then inquiry, and after that 30 days for appeal. All right. Next is there has to be a declaration by the parties. That is covered under section 11. Before the marriage is solemnized, the parties and three witnesses. How many witnesses should be there? There should be three witnesses. Shall, in the presence of the marriage officer, sign a declaration in the form specified in the third schedule. I'm sure many of you must have seen some sort of a thing in movies, in Bollywood movies especially. So yes, there has to be witnesses, and there has to be a marriage officer in front of whom a declaration has to be signed, and that is there in the third schedule. Also, after the signature of the witnesses, the parties, uh, also the declaration has to be countersigned by the marriage officer. All right. Now, section 12, it talks about place and form of solemnization. The marriage may be solemnized at the office of the marriage officer or at such other place within reasonable distance therefrom as the parties may desire, and upon which conditions and the payment of such additional fee as may be prescribed. The marriage may be solemnized in any form which the parties may choose to opt. Now, for example, there's the witness. There's a person who says that I A take the B to be my lawful wife or husband. Like a person A, he says I A take the B is any other person to be my lawful wife or husband. So this is complete and binding on the parties unless each party says the other in the presence of the marriage officer and the three witnesses and in any languages understood by the parties. It is binding and it is complete. Now, Section 15 of the Act, it talks about registration of marriages celebrated in other forms. Any marriage celebrated whether before or after the commencement of Special Marriage Act 1954 may be registered under this chapter by a marriage officer in the territories to which this act extends or the following conditions are fulfilled. Number one, neither party has at the time of registration more than one spouse living. The parties are not within the degrees of prohibited relationships. A ceremony of marriage has been performed between the parties and they have been living together as husband and wife ever since. There should be the ceremony. For example, in Hindu marriage, we have this satpadi. In Muslim marriage, we have nikah. So that has to be there. Something which tells that yes, they have been married and they have been living together as husband and wife ever since. From that point onwards, when they perform the marriage ceremony, they have to be living together as husband and wife. Also, neither party is a lunatic or is not mentally capable of making decisions at the time of the registration. The person should be of complete sound mind. The parties have been residing within the district of the marriage officer for a period of not less than 30 days immediately preceding the date on which the application is made to him for registration of marriage. Now, what does this thing state? It tells us that if somebody, like many people, they run away and then to get married, and if they want their marriage to get registered, they have to wait for at least 30 days to stay, to reside at that particular district if they want it to be registered. All right. And the last one is the age of the parties. It should be for male, it is 21 years of age. Actually, it is for both of them. Both the parties should have completed 21 years of age at the time of registration. It is about people who have had their marriage earlier, whose marriage was solemnized earlier than the Special Marriage Act 1954. So their parties have to have completed the age of 21 years of age at the time of registration. Now, what is the procedure for registration? It is covered under section 16. Please make note of the sections that I'm telling alongside the what the section is about. Okay, so application side by both parties to the marriage for the registration. Then the marriage officer, he has to give public notice thereof in such a manner as may be described. He gives the notice, it is there, then objection period for 30 days, and then 30 days, if there is any objection, 30 days for inquiry, and then 30 days for appeal. This is the registration procedure. Now, section 19, it talks about effect of marriage on members of undivided family. The marriage solemnized under this act of any member of the undivided family who professes the Hindu, Buddhist, Sikh, or Jain religions shall be deemed to effect his severance from such family. We'll have another video for Hindu undivided family, but for now on, this is the provision under the Special Marriage Act regarding Hindu undivided family. The succession, it is talked about in section 21. It states that notwithstanding any restrictions contained in the Indian Succession Act 1925, 39 of 1925, with respect to its application to members of certain communities, succession to the property or any person whose marriage is solemnized under this act, and to the property of the issue of such marriage shall be regulated by the provisions of the said act, and for the purposes of this act shall have effect if chapter 3 of part 4, that is the special rules for Parsi section, that intestate, had been omitted therefrom. Alright, section 21A states that where the marriage is solemnized under this act of any persons who professes the Hindu, Buddhist, Sikh, or Jain religion with a person who professes the Hindu, Buddhist, Jain or Sikh religion, Section 19 and Section 21 shall not apply. Why? Because we have Hindu marriage, Sikh marriage, Buddhist marriage, and Jaina marriage covered under the Hindu law, under the Hindu Marriage Act. So they do not need to apply for under Special Marriage Act. All right. Now, grounds for divorce. It is covered under Section 27 of the Act. It is adultery, cruelty, desertion for 2 years. Here, otherwise, the desertion period is for 7 years, not heard or seen. But here, especially under the uh, Hindu law, it's for 7 years. But here, it is only for 2 years. Next is unsoundness of mind, venereal disease, leprosy, and not heard for 7 years. Actually, desertion here, I'll tell you, desertion is when you do live together but you do not have conjugal relationship. That is what desertion means. The next ground for divorce is non-resumption of cohabitation after passing the decree of restitution of conjugal rights for 1 year or more, non-resumption of cohabitation after passing the decree of judicial separation for 1 year or more, undergoing a sentence of imprisonment for 7 years or more for an offence under IPC. Also, the special grounds for wife is husband guilty of rape, sodomy, bestiality, and 1 year after decree of maintenance. So I hope, guys, this topic was clear. Also, for any questions, doubts, feedback, please feel free to use the comment section. Uh, I'll be responding to them as soon as possible. Also, this video is specially for educational purposes. No kinds of advertisement are supported in this video. Thank you, guys. See you in the next video.